Thank you. Please remain standing for just a minute. I neglected earlier to allow the clerk to do his ceremonial duty, which of course has no bearing on the submission of the previous case, but is important to the court nonetheless.
Oyez, oyez, oyez. The Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas and this honorable court.
Thank you. Please be seated. We'll hear argument in 230875, Thompson versus Landry.
May it please the court, Mr. Hoopman will present argument for the petitioners. Petitioners reserved 5 minutes for vote.
Chief Justice, if you will please the court. There's several ways to enter into this conversation, but the way I think is the most efficient to do it is to start with the basic facts, which was the default judgment, and then 21 months after that default judgment, the deed to my client was signed from the sheriff's cell, and then 1 month after that, the deed was filed, and then 18 months or 19 months, the lease in question was signed. The lease that I'm saying was the actual notice was about. The reason why those dates matter is because...
Is it 18 months after, or is it, because the brief says August 2008 for the date of the lease, but the lease says August 2009. Does that make a difference?
It was signed on August the 3rd, 2008, and that does make a difference. Because
But if you look in the record, the date is 2009.
Whatever the lease says, I believe that I had calculated that the reason why it matters, whatever's the actual fact on that point is not debatable because it was established and there's a lease signed. But what matters is if they lost their time period under the two statutes for their legal remedies to come in and rectify the
The point is that sometime ahead of that, they had to have an understanding that they were no longer owners if there was a lease. Sometime before signing a lease, they had to have an understanding that they didn't own it. Is that's the legal significance of the lease?
Well, the lease does put, from my perspective, it puts actual notice on them about the existence of the default judgment. And
right.
so they're saying that they didn't know about it, and they couldn't perhaps not know about it because they were not actually served with the citation. But the lease is we know that they did know about it at that point, and so at that point is when they should have done something to try to get out of the lease.
So your point is after that, some sort of limitations period began to run after receiving actual notice. And what would that period be?
What the statute says, there's two statutes. You have the statute that gives them the right to sue. That's under Chapter 33 of the tax code. They have 2 years to sue from the point that the deed was executed. Okay, they also have a right to redeem under Chapter 34, which runs from the date that the deed was filed. And so both of those limitations periods are 2 years. And they run from the date of execution of the deed and then the date of signature. And so that is significant because depending on when the lease was signed, and I thought it was 2008, but perhaps I have that wrong, that's going to give them time to still go in and assert those legal remedies. Because if they have a legal remedy and they have time to assert it, then they can't come back in later with their equitable remedy, which is
So your point is the equitable remedy is not infinite. At some point, you've got to assert your due process violation upon learning what happened, upon receiving actual notice.
Well, they have the legal remedy under the statute of 2 years, right? And so they can assert their legal remedy if they know about it. And so if they can assert the legal remedy, that kicks into the due process analysis because the due process clause does not require actual notice. That's the best notice that you can ever possibly have according to multiple cases, according to cases out of this court. And so you must give someone actual notice if you know about their actual location, right? So to satisfy due process.
Right, and it sounds like the Court of Appeals was remanding on the issue of the efficacy of the service and all of that. But then I think your position is that even leaving all of that aside, there was actual notice,
Yeah, they had
which
actual,
eviscerates any due process defense.
since there's actual notice, there is no due process violation because under the Texas statutory rules regarding service, you can actually know about a lawsuit being filed, but if you were never served, according to the technicalities of the rules.
Can I ask you about that? Because we've been talking about actual notice of it. I want to focus on what the it is. Because the restatement refers to notice of the default judgment itself. Is that required or is there, like on these facts, I think your position is that that's not required because you're on inquiry notice once you know something less specific than that, once you know that there's a new owner, for example. Is that sufficient to trigger notice as a matter of law?
Okay, there's multiple notices going on here. You have constructive notice, you have actual notice, you have statutory notice because you're a taxpayer. You're supposed to go down and pay your taxes. Because when you pay your taxes, you're going to see if someone else is paying your taxes. You're going to be on notice then.
But
Okay.
we said that's not enough, and in the other cases we've had, Mitchell and
Mitchell.
others.
Right.
Just the fact that you're supposed to pay your taxes, it doesn't give
I-
you notice that they've sold your property.
I agree with that. But for due process purposes, you have to factor that in, right? So in the Mitchell scenario, where if all you have are facts where someone a person like me is saying, well, they didn't go pay their taxes, that is not enough. Mitchell makes that crystal clear. Okay, but the due process cases from the U.S. Supreme Court and that are used repeatedly by this court in multiple cases, ER and all kinds of other ones, they require the court to look at the totality of the circumstances to figure out what due process requires in the service of process scenario. That's why sometimes, a lot of times, most of the time, you do have to give actual notice. You send someone out to hand them the citation, here you've been served. But if there's nothing for you as the plaintiff to know where that person is, and if you really, really want to find them, at one or two of the cases say, we're supposed to give enough notice for someone that really wanted to find them where they would go out and do that. So, but if there isn't anything to indicate how you could really, really find them, then you do not have to give actual notice. The due process clause is satisfied without actual notice in that scenario, okay? And so in the Mitchell case, it was just there was no service, no notice at all. So that violates due process because they could go look in the records. And of course, the court went through and explained that you have to also look at the deed records. You're not limited to the four corners of whatever it is. So you have to look at what's out there so you can try to give them actual notice or the best notice that you possibly could. Okay, so with all that just said, the whole point of the due process inquiry is what are the circumstances, the totality of the circumstances. Here you have the requirement that you should pay, but you have more than that. You have the lease that was signed and all these other circumstances that we're talking about. And so then you get to the really interesting question, because it doesn't seem like it's been really squarely answered, which is...
So what did the signing of the lease and the knowledge that her husband was paying rent to somebody, what did that give her notice of?
That gives her notice that the people, you don't sign a lease if you own the property, right? So they got notice that, it would seem like they got notice that the property was sold and therefore notice of the default, because why else would they sign the lease? And it certainly puts you on a very heightened level of duty to go out and look before you sign the lease, is there a default here? Because they know they didn't pay the taxes. So I mean, to me, it's just proof positive, to use legal speak. As a matter of law, it's been established that they had actual notice. But certainly, notice that the due process requires to go look. But here they actually signed it, and therefore you have enough notice to overcome Mitchell. And then you also have a whole lot of other, okay, you got some, to me, deep legal problems here that you got to sort out.
I mean, in a more traditional sense, whenever you're just having regular service, you know, you have to prove that you were actually, that the defaulting party has to prove that the person was really served and that the citation was signed and that it's been on file for some number of days. And, you know, actual notice doesn't mean anything. Now, if you appear in court, that's different, of course, because of the rules. So can you explain what the difference is really?
Yeah, yes. Okay, so the Texas rules regard all the different ways that you could serve someone under the Texas rules themselves. They give more protection than the due process clause. Okay, so if you don't get all the protection that the Texas rules allow, and they take a default, you can't get that set aside, even though you got more protection than the due process clause requires. But you got to raise that on a direct appeal. Okay, here we're on collateral attack. And so y'all's case, the PNC case talks all about this. Where it's collateral attack, the judgment is presumed to be valid. And so now they have to come back in and satisfy, and now the focus is solely on the due process, federal due process clause about did they get enough notice and such. And so the Texas rules on service basically are, you don't even look at them. You just looked at was their due process. And that's where the actual notice thing kicks in. And all the famous cases that start back with Mulan and then they come up after that essentially say, you look at the circumstances to figure out, which is why I was saying Mitchell's obviously applies here because it's the same statute in question, but the circumstances there were completely different than here. And so you look at the totality of that, and then you come to the lease, which is obviously the crux of this case. And okay, then you have what I was trying to say is it seems like a deep legal question. So it's void at the very beginning, right? If there's no due process. Okay, so there is due process, but the fact that gets you the due process occurred after the default judgment was signed. Okay, so then you start having to ask yourself, well, can you look at the fact afterwards, right? And so then if you look at Restatement 66, that's a common law concept that has come about and it's applied in a lot of family law cases, and this court, of course, applied it in one family law case, and then there's a bunch of other states that have applied it in a whole lot of different scenarios. But you look at the equities behind it. And so I think here, and the court may disagree with me on this, but I think here that because it's a personal jurisdiction question, it's not a subject matter jurisdiction question, you can just kill it under purely the due process clause. But if there was no subject matter, then it's never ever referable under any set of circumstances.
So let me ask you this. I think we have some other cases that say, in other contexts, other types of limitations periods not involving due process, but that if you discover, say limitations runs from a time that, you know, that there's an injury, but you may not have notice of the injury, and that's often the case. But somebody may raise the discovery rule, for example, but if you've discovered the injury before the period of limitations has run, I think we have cases that say the limitations period's still going to apply. It doesn't run from the time of discovery and you get 2 more years after that, right? As long as you've discovered it during the limitations period, then you don't really have a discovery rule argument, and the regular limitations period just applies. Is that your understanding of how that works, and would that be analogous here?
It feels like it's analogous, but I actually don't think it is because it's a due process analysis. I guess those cases ultimately become due process because if the surgeon leaves a scaffold inside of you and you figure it out about it 10 years later, it's not fair to not let him bring the suit unless you run the limitations from that. But that really, to me, invokes the discovery rule, which is really quite independent. of the due process analysis because of the Mulan opinion. And Mulan, again, goes back to the circumstances that's fair to give in, because it's really a personal jurisdiction question, right? So it's a no-notice jurisdictional question versus a no subject matter jurisdictional question. Well, if they got notice, even if it's after the fact, it's fair because they still had time within which they could go remedy their situation. And so you get out of this whole formalistic notion that it was no jurisdiction and therefore it was dead at the moment that it was signed. The order was void at the moment that it was signed. Not so if you applied Mulan and the totality of the circumstances, because you're focusing on what's fair to this individual to get personal jurisdiction. And so I think that you can actually decide this case actually without Section 66 of the restatement, because Section 66 doesn't, it doesn't really.
Your time has expired. Are there any further questions? Thank you, Mr. Hoopman. We'll hear from the respondent.
May it please the court, Ms. Elizalde and Mr. Kirkpatrick will present argument for the respondent. Ms. Elizalde will open with the first 15 minutes.
Mr. Chief Justice, may it please the court. The fundamental issue in this appeal is whether May Landry, and I'm going to paren Mitchell, because this tracks the Mitchell case almost exactly. If I had to write a guidebook or a playbook, I couldn't track two cases more similarly, except for the fact that our case is a homestead case versus the mineral rights out of Pecos County.
Well, and also, it seems like there's at least some evidence that your client had notice of the sale within the limitations period here, which wasn't the case in Mitchell.
And that is not our position, because as was asked earlier, that lease, which has been relied upon and provided to the court by Mr. Hoopman during the evidentiary hearing, it clearly states that it was August the 3rd, 2009. Not 2008. There's nothing in the record that indicates that there was a lease executed in 2009, and I've raised this in almost every single brief that I've filed.
Right, but even if the lease hadn't been executed in 2008, what the 2009 lease says is sometime before 2009.
Well,
They became aware.
Yeah, but our position on that is that, once again, I need to direct the court to the fact that this is a tract of land that is owned from Mrs. Landry's maternal side. It's her separate property, so she inherits through herself. This isn't a community property. If there's any evidence on this lease that it evidences anything, which I'm not disputing that lease exists. What our dispute is, did she have actual notice? And in her testimony, she said she didn't know about the lease, and that when
But she acknowledged that she knew that the rent was paid.
She knew that her husband was making payments, but she didn't know for what.
To the Thompsons.
To Mr. Thompson, but we don't know for what. So what I'd like to say is that
Well, does the record indicate what she thought it was being paid for?
No, she didn't. She didn't indicate.
How much was it?
$30? $30? Less than $60? So a negligible amount? I don't know. I mean, I can't proffer as to what I think it could be for. I'm just saying it was a minimal amount. So I go back to...
And then let's at some point, so if we take the date of the lease.
Correct.
And that was in 2009, and then the suit in this case doesn't get filed till 2016. So is the lack of notice a perpetual defense? Or is there some obligation for someone who doesn't have notice to assert their due process challenge within a reasonable period after having actual notice?
Well, as a litigator, someone who litigates, I get a judgment. I'm going to execute on that judgment. So the judgment in this case has language. Writ of possession may issue. No one went down to the courthouse, paid the fee to get a writ of execution. So let's take it forward to the tax sale.
Right, because I think there was an eviction proceeding, right? And that came after several years of lease agreements. So.
Of the sole lease agreement executed only by Frank Landry, not May Landry. No evidence in the record that indicates May Landry knew anything about this lease other than her husband is paying something to somebody, and we don't know for what. She testified that she saw Mr. Thompson on the property, but, I mean,
She certainly became aware of the eviction proceedings.
in late 2015. And when that happened, that was in the JT court, got appealed to county. From county, that was January of 2016, and by, those proceedings took place in the early spring of 2016, and then we were in this case by May, June. So there was no tardiness in terms of running to the courthouse to exert your rights. Yeah, that was done very, very promptly. Once the discovery was made at that level, what had happened in 2005?
So you're saying that the record indicates that the first time she actually knew about this was with the eviction proceedings?
Yes. And in the eviction proceeding, also within the record, this record is rather voluminous because so many different things have been filed and it's just really extensive, but yet the facts are so simple. Let's see. What I'd like to also go back to is the order of sale, because the county struck off the taxes. So it went from whatever was owed to zero. Then they placed the property up for sale very shortly thereafter. The Thompsons come in and buy almost a 12-acre tract of land for $2,900. Thompson doesn't do anything. She would have still been within her direct line to come in on a 2-year, come in, try to set it aside, come in on a bill of review, try to set it aside. Nothing happened on this case by the Thompsons. The Thompsons made no overt acts until after the 4-year statute of limitations had expired. When they bought their land, they held on to it for 2 years without doing anything. So I find that important because this court last summer in the Lakeside case, it was a mandamus case, and in that case, the plaintiff served the corporate defendant, the registered agent for service. There was a glitch. The defendant never got notice of it, and then the plaintiff waited until after the plenary power of the court had expired before they abstracted their judgment, and then sent it off to the defendant at an address that was not in the original petition, but was the general business office address for the defendant. At that point, they became aware, and this court, in the language, said, you just waited just enough time. And that's what happened here.
So we're dealing with a statute that is not just a statute of limitations, it's also a statutory guarantee to the purchaser that the purchase is conclusive. And so would you agree that there's somebody else on the other side of the due process equation who we need to consider as we're thinking about how what constitutes due process given this statutory scheme?
I always think there's a consideration of both sides of the fence, but I also want there to be some consideration to the fact that May Landry, if you go and look at the rules which apply to the tax, and this is discussed in the Mitchell case, it's discussed in Mennonite, you've got it in Flowers, it's all over the place. She lived on that property her entire life. If I were to take the account number on the front page of the petition, which is 0569 or something like that, and if I were to call the tax office, don't forget that the tax office had renditions. May Landry had rendered, there are at least 5 or 6 people who had renditions for this property in the tax in the county tax records. Those people should have all been noticed with personal citation. The record is devoid of any request for personal citation. There's no returns that say personal citation was unserved. And yet,
The Court of Appeals said there was a fact issue about
Yes.
whether the taxing authorities provided proper notice and citation. So as leaving all the other people aside who are not parties.
right, that's right.
As to Ms. Landry, what is your allegation on the face of the record showing that the process of notice and citation was defective?
It's completely defective. No, she should have been given personal notice under 117. She's a person with an apparent interest. Renditions were filed. That's in the next paragraph of 117. None of that was followed. Within the court record, there is something with the citation by posting. It's odd because the file stamp of the citation by posting is file stamp September of 2016. So it doesn't appear that that was in the record or not. I'm really not sure what to make of it, but I wanted to bring that to the court's attention. If you look at the dates that are on the citation for posting, there's some sort of a stamp, but that, I would submit to the court that that's just the constable office's stamp that says 7/27/2004.
But unlike what happened in Reeves County in the MAP case, in this case, there was one defendant that was personally served. And then multiple other defendants, ad litem was appointed, and a whole process for attempting to notify those defendants. But you're saying that process, that you can demonstrate that process was ineffective?
Absolutely. The Rule 244 ad litem was appointed. He only files an answer for one defendant, Jasper Ford. We already know that at least 4 of the folks on the petition were deceased because that's noted on the petition. The ad litem testified that he didn't, after his appointment, he didn't go out to the property. He relied on what, he said he relied on what the government plaintiff had done as their diligent inquiry. He made no diligent inquiry on his own. One of the things that has disturbed me on all of this was that subsequent to all of this, in 2015, we had an amendment in the tax code that ad litems had to file their own independent statement of evidence, which said what you needed to do in a tax case. And there is a laundry, in the county that I practice in, there's a laundry list that you have to go through, and you have to check it off and submit it to the court before a judgment will issue in a tax foreclosure lawsuit. So from my perspective, there are errors, many errors here that would make this judgment that personal jurisdiction did not attach on this case. And so I believe this judgment is void, and the deeds that have issued through it should be declared as void. If we come in with what did the tax sale purchaser who buys, the argument there would be what they took is only what the sheriff can give you. And if what you got wasn't good, then what you get is defect. It's like a quick claim. You just buy, let the buyer beware. And these were seasoned investors. They knew what they were doing. They testified, Mr. Thompson, he's deceased now, testified that he knew all about limitations. And that was, and as to the 2-year redemption period, and as to the 4-year bill of review period, there was no question about that being in the record.
Let me ask you about latches. So I understand your position that your client acted timely once she knew something, but suppose there was a case where somebody, no notice of the sale happens, and 5 years later they find out about the sale, they enter into a lease, and then they're evicted, and then they wait another 5 years to sue. So they knew, and they could have sued much earlier, but they wait 5 years. What does the law say about whether latches can run against your right to declare a judgment void? Because a void, we have cases saying a void judgment has no effect, and so presumably that could be declared at any time. But are there any cases that say you look at latches in that circumstance, or not?
I can't say that I have anything that I could submit to the court on the issue of latches. So,
Was there anything in the record that indicated what the fair market rental would have been for that property?
no,
Nothing
nothing at
about
all.
comps or anything like that?
No, Chambers County, where this property is located, is near Anahuac. So once again, I go back to what were things like in 2004. Certainly very different than it is today. It was out, I would say it was out in the country at the time.
Now, be careful, I grew up in Baytown.
Well, I really like that area. So, the thing that has always disturbed me on this case is that there is a Farm to Market Road there, that's fairly large. It runs, you know, I can't think of the directions. But right off of that is the street called Ford Lane, which is the entrance to this property. And so when the record that you would be looking at says, I made a diligent inquiry, I looked at the records, none of that makes any sense because of the fact that there is a road, there are houses, there are 6 residential structures on this property. So going back to what you do when you're a plaintiff and you start your lawsuit, I order citations, I give them to my process server, he runs out and says, and just because I'm looking at a meets and bounds description doesn't mean that I'm not going to look to see what's the address. I could have called the tax office and said, Denise Hutter, what's the address? She would have said, oh, it's on Ford Lane. Well, Ford Lane tees into 535 or for whatever that road is. I would have driven out there, send the process server out there. He would say, hey, there's 6 houses here. What do
But
you
by
want
the
me to
same
do?
token, I understand all of that, but by the
Right.
same token, the taxing authorities, the school districts, and they were sending, you know, tax notices to Ford Lane for 16 years that went unpaid.
Well, there are P.O. boxes. You don't get mail at your house there, the way that it's structured. Nobody does out there.
You understand that
Right.
kind of runs both directions.
Right, and right, notice of a debt isn't the same thing as notice of a lawsuit. There's a Wilson versus Dunn. You all defined what actual and service of process is, and saying that someone who was given a petition in their hand by their apartment manager, that was not held to be service of process in compliance of the rules. So,
Any further questions? Thank you, Ms. Elizalde.
thank you.
Mr. Kirkpatrick? I believe you have 5 minutes.
May it please the court. I've been dealing with this case for at least 8 years, and I've never seen something so appalling as a petitioner not even trying to comply with the rules. They were required to give personal notice to May Landry. They were required to list her as a defendant, and they did none of that. And then they passed it on by appointing an ad litem, and the ad litem didn't even do his job, didn't go to the property, testified he didn't. And then the judge, the final gatekeeper, should have looked at the record and said, there's no return of service on, even for the posting. And he didn't do that. So it's totally depriving May Landry of her due process rights, and it just basically shouldn't be tolerated. We'd like the court to declare it void, send it back, and let everybody have their opportunity to be heard at a meaningful time in a meaningful place.
Any
Thank you.
questions? Thank you, Mr. Kirkpatrick. Mr. Hoopman, you have 5 minutes.
The real issue in this case under the petition for review is latches and whether or not Section 66 of the restatement applies.
So what's your best case that latches can run against a void judgment?
That's why I was trying to make the distinction between personal jurisdiction and subject matter jurisdiction. If it's personal jurisdiction, you have to look at the totality of the circumstances that focus on the individual that was entitled to the notice. And here you just cannot get away from the fact that they signed the lease, and that's part of the totality of the circumstances, which at the same time then kicks in Section 66. And so Section 66, the whole idea behind it is that it does bar judgments that are final, even if they're void at the beginning because of all these equity concepts. And this court has said in the ER case that
Well, jurisdiction isn't an equity concept.
Section 66 is of the restatement. And so if the restatement, basically the restatement seems to me to say that you can avoid the consequences of a default judgment that is final if it unreasonably failed to take acts after knowing about the default judgment that's on the person that was given notice, and there's the substantial interest reliance part on our side. And so it does seem like the restatement could be a problem if the rule you're talking about is hard and fast.
Well, might the answer be that the judgment is only void if all things considered it violates, giving it effect would violate the due process clause?
Yeah, that's
And
obvious.
whether or not giving it effect would violate the due process clause is a question that entails considerations like latches.
Exactly. That's exactly how I view it. And I think that in the subject matter jurisdiction, I think you take that out because that's not what we have. So then what you just said absolutely squares the issue fairly, and then you look at the two elements of Section 66, namely, did they unreasonably delay, and then what are the reliance interests on our part? And so then when you start looking at the reliance interests, prong 2 of Section 66, you start looking at the reliance interest, then you got to look at the statute, because the statute puts this statutory right for us as purchasers to really, really rely on the sheriff's deed. And that's going to really chill the taxing authority's ability to sell properties if 10 years later, when you have an actual notice scenario, unless it's a Mitchell scenario, but if you have the other scenarios, purchasers are just going to really be, like my clients, really getting burned here. All these years of paying all these taxes, and then after the fact, they're going to get stripped of. So then Section 66 kicks in, and but again, you got to go back and look at the actual notice from the signing of the lease, which does what you said.
But it seems, if there's, well, I guess it depends on whether that was within the limitations periods. But if there was notice within the limitations periods, it doesn't seem like there's a due process violation and you wouldn't get to latches.
I would agree with that. If the notice, if they still had time to fix it,
Right.
then you never get to latches because they can prove up, their entitlement to being able to fix it.
Wouldn't
So-
an answer to your side of it just be to do it right in the first place?
You mean the service of process? Oh, of course. Oh, yes, definitely. But that was out of our hands because that was the taxing authorities that did that. Taxing authorities got the default judgment. And so they, if anybody screwed the pooch, it's them. But then we, under the statute, and if you go, you probably already have read it, but if you read this section in the statute, we really get to rely on the purchasers. They're not going to put hard-earned money on these purchases at tax sales unless they know it's a clean title. That's why they put that provision in the tax code so that the purchaser can purchase with absolute certainty that they're not going to have this giant, humongous, as he said, 8-year. This is the 5th appeal I've had to file on this case. My clients are the purchasers. The statute seems to them to be meaningless because this has been a very painful, arduous, costly experience when they actually have a lease signed. And so that really puts the hurt on the taxing authorities, I would think, on their ability to put these properties that are not being paid taxes on back on the tax roll so the government can function. Because, we got to pay our taxes so we can do all this stuff the government does. That's what this case is all about.
Any further questions? Thank you, Mr. Hootman. Thank you to all counsel. The case is submitted and the court will take a brief recess.
All rise.